Hello, everybody. It's Dave Neal, stand-up comic and host of Bachelor Nation News. We have an update with the Bachelor Clayton Echard versus Laura Owens court case going on. As we know, currently, Laura Owens has filed an appeal to the decision that was made on June 10th, or the decision was made a week after that. But on June 10th, there was the evidentiary hearing, which essentially sided with Clayton that Laura Owens needs to pay his court fees, legal fees that totaled around $150,000. Well, now they filed their appeal, and Woodnick, the lawyer for Clayton Echard, will issue their response to the appeal, and then it will go to 3 appellate judges, and they'll decide what they think. Should it be overturned or not? I've heard that roughly 90% of cases aren't overturned. Is this a case that deserves being overturned? We will have to see. What we have today is a lawyer who sent me a lengthy letter. Now, the last time I received a lengthy letter from a lawyer, it was quite bizarre, if I may say the least. It was a sort of legal penile measuring contest, as they say, I guess, at law school. And this is quite different. This letter that I received was from somebody who's been watching the trial play out. Now, I love when I get emails from people that seem to have a lot more expertise than I do. This is an email from a lawyer who practiced and is licensed in Arizona, is retired and graduated law school, I believe, in the 70s. So I'm going to share what they have to say regarding where they think the trial stands, having read and consumed all of the information. You know, very often people will say, well, Dave, what the hell do you know about anything? And my response to that is, not much. Unless you're talking about how to throw a splitter in a beer league baseball game, I couldn't tell you much about life. But what I can tell you is, I think I've got a decent intuition into listening to smart people and letting them share their thoughts. So that's what we do on the channel here, right? Not an expert. You know, there's a lot of LawTube is lawyers giving their opinion. Don't have one other than the information I've received, and just like you guys have made my decision that I believe, you know, barring any updated information that didn't make its way into the trial, that Clayton Echard is 1,000% innocent. And he's been framed as being the father of someone's unborn twins that never arrived. And it was, to punish him for being rejected. That's the opinion that I've come up with based on seeing the track record that exists. I think it's fair. To be quite honest, I think when you poll 1,000 people that have followed this, I think about 999 of them, unless you poll Jan, Laura's mom, will agree that that's what it looks like based on all the evidence we've seen. So with that said, let's read this nice email we received from a lawyer in Arizona. Again, they don't really claim to be an expert in family law, but what they will say is, like, you know, they're going to share their points. This might be a legal love letter. It might be a little lengthy, but I appreciate it so much. Not lengthy to me, but maybe for you guys. So get your popcorn and let's just go through it. My wife showed me the video you did with Reality Steve and Rachel Juarez. Adding Miss Juarez was a great addition to the podcast. Her experience in family law showed. I have not seen a better explanation directed to a lay audience of the intricacies of appeals. That said, she was obviously a little lost when it came to the intricacies of Arizona's approach to family law and the maintenance of the integrity of the court system. Regardless, you should pester her to be a guest whenever you are dealing with the Echard matter in the future. By the way, I would love to have Miss Rachel Juarez on as a guest, but she's also like Reality Steve's guest, so I've kind of not wanted to poach her. Do you know what I mean? Maybe I could have her and Reality Steve on, but yeah, I wouldn't want, not that he would care. He's not territorial like that, but I've kind of, out of respect to Steve, have let her, I've kind of let that relationship play out on his platform. It continues. I know that this program was done before Gingras filed his opening brief on Laura Owens' behalf. I have read the brief. The rest of this email relates to the brief in my view of the issues, but should be addressed by the Court of Appeals, or that should be addressed by the Court of Appeals. It is a collection of random brain droppings. My shout out to George Carlin. First, I don't understand why everyone is letting Gingras establish the playing field. Gingras spent the 2/3 of his brief arguing something that should not be a major issue in the appeal, namely the safe harbor rules for seeking sanctions when a person files a frivolous pleading. Gingras is correct when he claims that a condition precedent for seeking sanctions for filing of a frivolous pleading is a demand that the offending party withdraw that pleading. If all we were talking about here was some random off-the-wall pleading that led to sanctions, the judgment should be overturned. The problem here is that situation before the Judge Mata was not merely a question of sanctions for filing a frivolous pleading. It is more than that. Judge Mata was faced with the issue of what she should do about a party's abuse of the discovery rules and that party's lies made under oath in order to hide relevant information. Stated another way, what is a judge to do with a party tries to subvert the court system? A system that relies on parties and witnesses to tell the truth. Oh my gosh, I already love this so much. I love that this lawyer who emailed me, we're keeping anonymous, who's worked for seemingly half a century in law. This lawyer saying, what are we to do if we're not to uphold the system that's supposed to keep people telling the truth? And a lot of people will argue, like Jinger says, oh, they never prosecute perjury or they never do this and that. Well, maybe not. But maybe this is the absolute worst time to ever lie under oath and tell mistruths and, like they said, subvert information. If they don't want to call it perjury, there certainly was the subversion of information. What better time than now to try to get back to crossing our T's and dotting our I's? There is no question that Laura Owens' conduct was a perversion of the court system. She is required under the disclosure rules to give Clayton Eckert all documents in her control that are relevant. The initial discourse is due 40 days after Mr. Eckert answered the petition. Owens produced no documents, even though any records relating to her pregnancy and her prenatal treatment would have been relevant. That's right. She didn't release documents. She kind of like signed a waiver that Clayton could then go find the documents, which is funny because it would end up costing her more money because they had to do that on billable hours. If it were me and I would do it, and if I was telling the truth, I would give them all the information. Hey, no need to go further. Here's everything you need to know. Problem is, the information she gave me was doctored medical evidence. She so completely ignored her obligation to exchange information that she was eventually ordered while she was at a hearing to sit and write down name and location of each healthcare provider she saw in the years before her petition was filed. Interestingly, her list was a lie. She identified doctors that she thought about going to, but didn't. This wasted Greg Woodnick's time and Eckert's money because they had to follow each bogus listing down a rabbit hole to find out she was not treated. By the way, this lawyer that we're speaking to right now that's emailing me, they know their shit, right? They're going back to things that were done in April. They're going back a long while here. And Miss Juarez, Rachel Juarez, she's new to the case, so she can only know as much as she knows, and there's still a lot. And I know Rachel has tried to catch up, but, it's like I said before, this is drinking water out of a fire hose right here. The fire hose, not a metaphor to Clayton Eckert's, well, Anyhow, that's a different story. So interesting that this lawyer here who's watching the case and by the way, I know you guys all understand this already, but this idea that everyone who emails me would be lying, like we have yet to receive a lawyer's opinion on this case that is not on the side that the judge came to. So we have yet to see a lawyer. And by the way, lawyers love a good loophole. Lawyers love a good loophole. If there was a way to wiggle out of this, I'm sure lots of lawyers would say, well, there's the clause 99. According to clause 99, that doesn't exist. As far as anyone has been able to see. The only thing that Gingras is grasping on, like he says here, is this Rule 26, which isn't the only, I guess, decision-making factor here. These actions, so anyway, calls her a liar.
She lied?
These actions, though reprehensible, were a sideshow to the thing that I believe really precipitated Judge Mata's ruling and the referrals to the county attorney. Those actions relate to the testimony she gave under oath. And again, this is just a lawyer's opinion here. She had previously, but we take that highly because this lawyer seems to know what the hell he's talking about, he or she. She had previously provided an ultrasound that was supposed to have been administered at Southwest Medical Imaging, SMIL, Owens testified that she altered the ultrasound by adding the facility name and date of the image. At her deposition, she claims that the ultrasound was actually administered at the Planned Parenthood facility in Mission Viejo on July 2nd. After that organization stated that Laura Owens was not a patient at that facility, she testified that the ultrasound was actually done at a Planned Parenthood facility in Los Angeles and that she was treated under a fictitious name. When asked why she did this, she provided an answer that suggested that her testimony under oath was given to prevent Clayton Echard from actually obtaining a copy of her medical record. Interesting. Yeah, now she said, oh, I didn't want him stalking me. But what did she really want? She wanted to make sure Clayton couldn't come check out whether she was telling the truth or not, because now we know
she lied.
She lied. The policy of Arizona courts is that open, early exchange of relevant information is required for cost-effective resolution of cases. Despite their location, the Arizona courts do not subscribe to the notion that court proceedings are an extension of the wild, wild west. Trial by ambush and misdirection are not tolerated. Moreover, the Arizona court system depends on litigants and witnesses taking their oaths as a mandatory obligation, not merely a suggestion. Lying under oath is such egregious conduct that it is a crime, perjury. Knowing that perjury is oftentimes difficult to prove, the Arizona legislature adopted a special statute, that deals with inconsistent testimony given under oath. ARS Section 13-2705 says, when a person has made inconsistent statements under oath, both having been made within the period of the statute of limitations, the prosecution may proceed by setting forth the inconsistent statements in a single charge, alleging in the alternative that one or the other was false and not believed by the defendant. In such case, it shall not be necessary for the prosecution to prove which statement was false, but only that one or the other was false and not believed by the defendant to be true. Ms. Juarez made the statement that nothing might come from the referral because perjury is difficult to prove. Ordinarily, she would be right. In this case, the prosecution would not be terribly difficult. The roadmap to conviction is in the quoted statute. Taking Laura Owens at her word, the deposition testimony was false and known to be false. It was given to prevent Echard from finding out the truth. Again, taking Laura Owens at her word, the trial testimony was true. She committed perjury by inconsistent statements, and she does not have any real defense to this charge. Oh, it continues. Gingras is trying to tie the sanctions to the complaint that was filed. If he is successful, the judgment will be overturned because Woodnick did not follow the rules for sanctioning a party for filing a frivolous pleading. But the sanctions against Laura Owens were not based on the filing of a frivolous petition. Rather, they were the crap she pulled, which went against most everything the Arizona court system depends on to administer justice, namely timely disclosure of relevant information and honest testimony. Notice that none of these things are pleadings. The safe harbor rules do not apply to giving false testimony under oath or lying in discovery responses. If I were Woodnick, I would start the argument in the answering brief with a simple declaration that 2/3 of the opening brief was devoted to something that is not an issue in the case, namely the sanctions in the case were not the result of filing a frivolous pleading. I would declare that Laura Owens was sanctioned for her criminal conduct that was nothing more than an attack on the integrity of the court. I would then discuss the law that gives the court the inherent right to control the proceedings before it. I would also rely on a statute cited in Mr. Echard's answer, which says, in any civil action commenced or appealed in a court of record in this state, the court shall assess reasonable attorney fees expenses if the attorney or party does any of the following: brings or defends a claim without substantial justification, brings or defends a claim solely or primarily for delay or harassment, unreasonably expands or delays the proceeding. Motion for lunch, anybody? Engages in abuse or of discovery. Do you think any of these four categories apply? How about all four? Damn, this guy's good. As a side note, a proper reply brief can only deal with issues raised in the answering brief. By focusing on Laura Owens' criminal testimony in her alteration of documentary evidence, you force Gingras to do the same. This would impair Gingras' attempt to make the appeals about safe harbors. Second, it needs to be pointed out that Judge Mata's decision on Laura Owens' dismissal request was incorrect. The family court rule that applies to voluntary dismissals gives Miss Owens the absolute right to dismiss her case before the answer is filed. After the answer is filed, the dismissal is allowed, but only under the terms set by the judge. Laura Owens asked for her dismissal after Clayton Echard filed his answer. The answer included assertions that Echard did not have sexual intercourse with Owens, that he could not be the father of any child with her, and that her action was frivolous. So Judge Mata could allow Owens to dismiss her petition while at the same time allowing Echard to prove his claims. Given her criminal behavior, Owens is not in a position to argue that no fees would have been incurred if the entire proceeding was dismissed as opposed to just her part. Her lying in misdirection done with the intention of subverting Echard's right to information relevant to the case makes the runaway attorney's fees her responsibility. All right, so what I'm reading here as an idiot is that you're saying Clayton has the right to share his response as to why he's not the father. Therefore, there will be attorney's fees whether she wants them, wants to dismiss or not. Third, Gingriss's fixation on Judge Mata's father attending trial is a red herring. Trials are public proceedings. Relatives of the parties, the lawyers, or the judges are welcome. I once was involved in a salacious case involving the state of Arizona. There was a lot of swearing and graphic sexual actions that occurred during the events that were relevant to the trial. The jury, for some reason, was primarily from a retirement community. The case went on for 6 weeks. Every Friday, the courtroom would be packed with friends of the jurors who would have heard palpitations because of all the rather raw language in sexual acts that were described by the various witnesses. It was fun for the jury and their friends, embarrassing for lawyers and witnesses, and perfectly proper because the jurors did nothing but invite their friends to the trial. Yeah, this idea that it's a red herring is interesting because while that may be true, it also may cost him his law license. So it's like, sure, it's a red herring, but also it's going to come with some collateral damage. Fourth, Gingras is a master of bootstrapping. In this context, I mean he assumes a legal doctrine applies without analysis of whether it actually does, and then uses his assumption to cast doubt on the results of the case. Bingo. What a great way to put it. We call it a loophole, right? But he's assuming something applies when it doesn't. He's basically trying to take every benefit of the doubt he can in every legal direction that he can to get his client off. Which, by the way, it's just going to, dampen whatever credibility he thought he had. In this case, he focuses on the findings that LA Planned Parenthood offices were closed on Sunday. I have no idea if this is true or not, but certainly it was a finding by Judge Mata. If Judge Mata went outside the record and did her own research, she was wrong. However, that does not mean that the judgment should be reversed. Gingras argues that this conduct constitutes a structural defect in the trial that mandates a reversal. There are two things wrong with the argument. Structural defect is usually a concept used to analyze the propriety of criminal cases. Out of 100 or so cases in Arizona that discuss that concept of structural defect, only one was not a criminal case. That one was a mental health case that dealt with the confinement of a person to a mental health facility. Since the confinement of a person to a mental facility takes away a person's freedom, that mental health case is analogous to the criminal cases that discuss the existence and consequences of a structural defect. Given the nature of the cases dealing with structural defects, I am not certain that it applies to a civil case. More importantly, the standard for determining that an error made by a trial judge in family court justifies overturning a judgment stated in family court, Rule 86, that standard is harmless error. An error is harmless when it does not affect the outcome of the trial. If the outcome could be affected, then a reversal of the judgment is justified. This is substantially different from the structural defect standard Gingras wants to apply. I think that's the first time we've heard that argument made. My fifth and final brain dropping is related to the fourth. It states with an assessment of what was at issue in the trial. Echard's answer tells us what was to be tried. That list includes the following questions. Was Laura Owens pregnant when the petition was filed? If she was pregnant, was Clayton Echard the father? And was Laura Owens' conduct in connection with the proceedings sanctionable? You cannot assume that because she filed the action that she was pregnant. That is a disputed issue that must be resolved by the trier of fact. And there was no evidence on that issue before Judge Mata when the trial begins. The evidence presented was relatively simple. Owens said she was pregnant. There was an assertion that the sexual act involved was oral only and that oral sex does not end in pregnancy. There were home pregnancy tests that indicated that she was pregnant and lab tests that showed little or no fetal DNA, indicating she was not. There was no other test done to confirm the pregnancy except an altered ultrasound, which would ordinarily be inadmissible because of the alteration under the best evidence rule. There was expert testimony based on altered records saying she was pregnant, and there was expert testimony that there was no confirmation of Laura Owens' claims. There were criminal efforts on the part of Laura Owens to keep Clayton Echard away from any healthcare providers that could support or could cast doubt on her pregnancy. Simply put, the issue of whether or not Laura Owens was pregnant and the identity of the father depended entirely on the credibility of Laura Owens. With that background, why would anyone believe a word Laura Owens said?
She lied?
She could have been telling the truth, but she destroyed her own credibility and perhaps buried the truth with her own lies and deception. The finder of fact in this case, Judge Mata, determines the credibility of the witness. Judge Mata found Laura Owens' testimony to be unreliable and thus concluded that she was not pregnant when the case was filed. She could have reached the same result by acknowledging the pregnancy while finding no proof that Clayton Echard was the father. Regardless, Judge Mata's most significant findings are unequivocally supported by the record. Whether Planned Parenthood is open on Sunday or not has no bearing on the outcome of the case. If Planned Parenthood was open on Sunday, would that have made the testimony that Laura Owens fabricated parts of the ultrasound she claimed was hers go away? Would that have made the claims that the ultrasound was administered in Mission Viejo truthful? Would that have made it possible for Clayton Echard to obtain confirmation of the existence of the ultrasound and confirmation of the accuracy of the image, even though he did not know where the test was administered? Would that have resulted in the discovery of the assumed identity used by Laura Owens when she went to her ultrasound? Would that have made Laura Owens innocent of perjury? Of course not. The hours of operation of Planned Parenthood in Los Angeles have nothing to do with the conduct of Laura Owens, where she lied to keep Clayton Echard from the truth.
She lied?
The error, if there was one, in the findings relating to the hours of Planned Parenthood operation could not and did not affect the outcome. It was harmless. Yeah, well, I would say, if anything, it just proved that she was a liar because Planned Parenthood wasn't even open on a Sunday. But we already knew that. So like you're saying, I understand that claim. If you got this far, and we did, I admire your willingness to review a random rant on the BS created by Laura Owens and Gingras' support of that fecal matter. I open this rant with a commendation of yours and Reality Steve's efforts to bring sanity in the form of Rachel Juarez to the issues discussed in your podcast. You have probably learned by now that the practice of law is very nuanced, and it is difficult for most people to understand the court system and its processes if they are not involved in it on a day-to-day basis. I appreciate your efforts. Keep up the good work. I'll tell you what. Now, do I have some sort of confirmation bias that when I receive an email that appreciates my efforts that I share it with my audience? Sure. But I also appreciate an expert not speaking down to me. I appreciate an expert, unlike Gingras, who just called me a liar and told me I was, only one-sided and I'm part of his fan club and I'm here to, whatever, all the graphic sexual references he made as to why I'm, whatever. Rather than that, we have someone who seemingly has practiced law longer say, look, no, you're asking the right questions, you're heading in the right direction, and this is why I agree with you on X, Y, and Z. Love it. So we always appreciate lawyers sending in letters. I don't always get to share them. I have to say, we must have thousands of lawyers that have been following this case, probably because they see, it's almost like this. If you watch a football game and a team wins 30-0, who's going to talk about it the next day? But if you watch a football game where the ref blew a call so bad, the next morning, oh my gosh, could you believe it? This and that. What happened here was, I believe lawyers are seeing Gingras I don't know if it's misappropriate or misconstrue rules to benefit him in a way that's so egregious that they're writing in saying, no, he's got it all wrong. He's completely bootstrapping, as they said. Now, again, and by the way, that's my thumb. Why is that right there? That's weird. It's my thumb made it into the edit. I didn't mean for that to happen, but hey, it's a Photoshop error. Anyway, that's the world we live in, and that's your content for the day. I will be sharing on the Rush Hour podcast our single mom wish list. So if we're going to have one lucky single mom or single dad in the next couple weeks that we donate to every single day, we're going to share their story and how we can help them during the Christmas season. Not a bad way to help out those in our community that are in need. Hey, by the way, shout out to Luis here for sending August, my son, his first baby book, Augie's First Christmas, along with a hat. How cute is that? Unbelievable, guys. The charity and kindness from our community is something that I was able to really reflect on over Thanksgiving. Thank you so much for being there for me and for being a part of this very kind, very wonderful community that we have. All right, the Rush Hour podcast is coming out next.